To expand a little bit and examine on the issues and the developments over the past couple of hours. We have constitutional law expert Advocate Romeo Ntauleni as well as Advocate Michael Osborne. And you are, of course, part of the conversation tonight by sending us through your comments on 072-110-5584, or you can tweet us tonight at Newzroom 405. Gentlemen, good evening and thank you for your time tonight here on In Focus. Let's get straight into it. Let's talk about this last attempt by the legal team of former President Jacob Zuma to get the stay of arrest, I suppose, pending the two High Court application as well as the Concord application for rescission of the court order. What is the legal standing, Advocate Romeo, of this particular letter?
Look, good evening, Thabo, and thank you for that introduction. In the normal course of events, when you write letters, you must also send that letter to your opponents. And I don't know at this stage, the letters that are being written belatedly, Nicodemously now at night as to what will be the procedural elements in terms of courtesy to write to the other party in relation to the response. So it's quite important that these people are not litigating on their own, but once again, it shows the different kind of nature of the matter that we're actually dealing with. It is actually the opposite. There is a long extension of extending courtesy to the former president in all the way, because you cannot write a letter without your opponent not knowing anything about that letter. And this letter seeks also to suspend the arrest using the incorrect procedure of using the threat of the High Court order that might be given or not given by the High Court in Pietermaritzburg. So you are asking the Constitutional Court to suspend its order based on the decision that you're waiting for in the Constitutional Court. For me, it doesn't make sense. And all the analysts were saying these things to say they were quite surprised by why the Pietermaritzburg High Court was being approached, and they were branded as pseudo-analysts and all that. But the fact of the matter is that the true test of the law stands, and now you can see what is happening to say what the lawyers were saying is correct.
Right, what you're seeing there, pictures of a motorcade of the former president, is we're presuming right now, and it looks like there is possibly some movement, and as soon as those developments are clearer to us, we'll bring you exactly what is happening, but we'll stay with those pictures and stay with our conversation with the two advocates. So, Advocate Osborne, the letter says we've lodged a High Court application to seek a suspension order of the Constitutional Court committal orders. It also says the SAPS have indicated that they will be executing the orders of the Constitutional Court tonight by midnight. In as far as wanting to stop the execution of a committal order, is this the process of suspending it?
Good evening. Yes, I agree entirely with my colleague. This is truly an extraordinary effort. It's simply not the correct way of approaching the Constitutional Court to write a letter. The way you approach the Constitutional Court, as you would approach any other court, is to bring an urgent application. And then, of course, that urgent application would have to be served on the other side, as foreshadowed by my colleague. The Constitutional Court is simply not empowered to grant relief of this kind by virtue of a letter. And the question would, in any event, arise if this approach is to be made late in the afternoon of Wednesday. Why was it not made 10 days ago? Why was it not even brought even yesterday? So I would think that in the ordinary course, this would be seen as entirely hopeless and even a kind of mischievous last-minute maneuvering using procedures.
One would say, sorry, Advocate, let me come in here. One would say this entire matter has been handled on an urgent basis. For example, the application for the rescission was also done, and the Concord replied during a weekend. They didn't have to wait for Monday. So I suppose all these matters currently are being handled on an urgent basis. Would that be out of process?
Oh, yes, an urgent application is quite in order, and it's not unknown for court to respond within hours to an urgent application. The point is they're not making applications, they're simply writing letters. And that's just not how litigation works.
Is it a sign of desperation in terms of where the legal team finds itself in tonight?
I don't want to characterize the legal team's motives. All I can say is that it's extraordinary and I think inexplicable that a formal application was not brought, even if it was brought at 10 o'clock this morning, within business hours, allowing the other side perhaps 2 or 3 hours to respond. But the letter at 5 o'clock in the afternoon is utterly unheard of.
Advocate Ntabeleni, I'm going to put you in a difficult position here as a legal advocate, and you deal with matters maybe not necessarily exactly the one as what we're watching tonight, but certainly when we think about the kind of negotiations, the talks that have been taking place between the former president's legal team and the authorities, if you were to think about the interests of a potential client, what are some of the things that you would have on that list?
Kathy, I think what is important is the way I litigate myself, I litigate with honesty and integrity. So I wouldn't be trying to ambush my opponents by bringing belated letters with a whole lot of lists that I require. What I will do is obviously do things within the right frame of time and actually approach the right court for the right remedy that I need at the right moment to actually avoid this kind of exigencies that comes at the late hours, as my colleague has correctly indicated. So it's not the way of litigating. I don't litigate like that. I wouldn't start now. I wouldn't do it even tomorrow.
Advocate Osborne, in terms of the negotiations with authorities, I don't want you to speak on perhaps what they could be discussing, but if you were to be handling such a case, are there particular interests of client that you would want to see addressed?
Well, yes, it fairly frequently happens that a warrant is issued for an arrest, and what will quite often happen is that the target of the arrest will voluntarily hand himself over at the nearest police station, and that will be the subject of negotiation. The problem here is that there's really no scope for negotiation. There's nothing to negotiate. The parameters of what is legally possible were established by the Constitutional Court more than a week ago, and which requires, firstly, the President to have handed himself in voluntarily by Sunday at midnight, and secondly, it imposes an obligation upon the Minister and the Commissioner of Police to make an arrest by midnight tonight. Those two obligations stand until such time as they are formally set aside by the Constitutional Court. And the Constitutional Court will not set those two imperatives aside except if a formal application is brought. So the notion of negotiations at this point is really quite meaningless.
Advocate Ntabeleni, as we are having this conversation, of course, there will be a lot of attention paid to really what happens next. So what happens from this point when he's arrested? Are we expecting that his lawyers will be with him at Westville Correctional Center, which is where we understand that the former president could well be taken?
Yes, in the kind of the nature of the letter that they have written, we expect that they will be with him, but their being with him is neither here nor there. What are you going to do? Because what should happen is that the police must make sure that the order of the Constitutional Court is executed. And as my learned colleague has indicated, in the absence of the application that is before the Constitutional Court, you are not going to be even asking for bail for him. So if you just want to accompany him for the sake of being there for the record, maybe you can do that.
Advocate Osborne, you've identified the fact that, this letter that has been written is effectively an exercise in futility. What does this mean? We've consistently heard about this assertion that the former president is receiving bad legal advice, maybe not, weighing in on the legal team itself, but in as far as developments have unfolded, do you think that that could well be the case?
I don't want to comment upon the quality of advice given by my colleagues one way or another. What I will say is that it's extraordinary, and I cannot think of any basis for the way that this particular stage of the litigation has been approached. But to follow up on what my colleague has said, yes, one would expect that the legal team would accompany their client to the correctional facility. And while I've said there's no scope for negotiation at this point as to whether the arrest will take place, where there is scope for negotiation and consultation is under what circumstances the former president will be held. We've heard, we've seen in the affidavits assertions that the president is, or the former president is in frail health. One would have thought that this would be brought to the attention of the Commissioner of Prisons, and that quite rightly that would be taken into account, and the former president would be accommodated perhaps in a private room or even in a hospital. So these are indeed things that are open to negotiation and that I would expect the legal advisors to be discussing with the prison parties.
Advocate Ntabeleni, there's been, of course, other debates around what happens now. If the president is arrested, does he get processed? Is an opportunity for him to apply for bail pending the two applications, one in the High Court and the one in the Constitutional Court?
As I've previously indicated, we cannot be talking about bail now. There's no application before the Constitutional Court that is asking for the stay of the order. What has happened is that they have went to the Pietermaritzburg High Court, and that action has actually backfired, because you can see the tone of the letter that has been written is trying to request the Constitutional Court to issue directives through a letter relating to the stay. And the judge in the Pietermaritzburg High Court has asked very pertinent questions relating to why the court was approached, and we had the issue of jurisdiction that was raised, the common law, and the arguments that were presented there. We'll wait for that particular kind of an order, but this letter that was written makes that order that is going to come after the fact even academic, because if the time the clock strikes 12 o'clock and the reports in the correctional services facility, what is the meaning of the order that will be granted by the court in Pietermaritzburg on Friday?
What is the attitude of the court? That we can read from this. Firstly, this is not the first letter. Of course, the first letter that came out was from the state prosecutor on behalf of the minister and the police commissioner, also saying, well, we seek clarity because we are uncomfortable really with carrying out this particular mission of arrest while there are still these pending legal matters. And I don't know whether they did receive any response from the Concord, and if they didn't, what would that tell us about the attitude of the court?
Look, the thing which is clear here is that you cannot second guess the orders of the Constitutional Court. What we have said together with my colleague here is that there's no application for a stay that was brought in the Constitutional Court. The order of arrest was given by the Constitutional Court. So to say that you are not going to execute the order of the Constitutional Court, you are putting yourself in the firing line of assisting and abating a recalcitrant party that does not want to comply with the court order. That is what was argued, correctly so, by Advocate Mugaitowi in court in the application. So you cannot say that you are going to wait for the process to unfold. You are actually breaching the law because there's an order of the Court, which is the apex court in the land that says you must arrest, and it gives you the directives on how to do that arrest by a failure of the party to actually present himself. So if we want to do a guessing work of second guessing the orders of the Constitutional Court, we can sit here the whole night and debate those kind of an academic exercise. When the order is being released, that order must be enforced. That is the law. And the law of the country must prevail without fear, without favor, and without prejudice.
Legal experts, Advocate Romeo Ntaveleni, as well as Advocate Osborne. Appreciate your time and thank you very much for joining us tonight here on In Focus. When we